and defendants absent.
Appearances, please.
With due respect to my lord,
Yes.
I am John Omugele for the claimant.
Yes, please.
With profound humility, my lord.
Yes.
I am AI Omachi.
Yes.
For the 1st to 7th defendants.
3rd to 7th.
Yes, 1st to 7th, my lord.
1st to 7th.
Yes, my lord. And may I, with humility, apologize for my failure to join up at the Zoom meeting the last time this month I came up. It was due to circumstances beyond our control, my lord. We are awfully sorry for that, my lord.
Okay, that is noted.
Most obliged, my lord.
So can we proceed straight to cross-examination of the claimant? Or are you, okay, we're commencing.
Yes, my lord, this for commencement of his cross-examination.
Okay, from the records, the claimant testified in chief on the 13th of December 2022. And we got to a point after Exhibit E had been tendered. Dr. Mugele indicated that that was all for examination in chief. So, Mr. Omachi, today you are cross-examining the witness.
Yes, my lord. We are ready with just a few questions for the witness, my lord. Subject to the convenience of the Honorable Court, we are ready to proceed, my lord.
Okay. So you may proceed.
As the court pleases.
So, Registrar, you are going to remind the witness of his oath.
Okay. Mr. Amako.
Yes, my lord.
You remember your oath?
I do remember, my lord.
What do you want to remind you of your oath?
I remember the oath, my lord.
Lord, the witness.
Because we are in the same room, you have to mute your microphones. All right, Mr. Omachi, you may proceed.
Very well, my lord. Colonel Osita Dima Uche Wanko, retired. Can you hear me loud and clear, please?
I can hear you loud and clear, my lord.
I'm not your lord. I'm just counsel for the 1st to 7th respondent. But for the purpose of this cross-examination, I will refer to you simply as witness. Hope you don't mind that, sir.
I don't mind that.
It's okay. Please, witness, how many types of How many types or categories of retirement are there in the Nigerian Army for commissioned officers as per the terms and conditions of service for officers?
I am aware of two kinds of retirements.
What are they, sir?
Two types?
Two types of retirement, my lord.
Okay.
Can you mind, would you mind mentioning the types of retirement, the two types?
Compulsory retirement and voluntary retirement.
Okay.
Yes.
Witness, will I be correct to say that your retirement falls in the category of compulsory retirement?
Yes, it does.
Okay.
Compulsory.
Yes, my lord, he said compulsory retirement.
Yes.
Witness, I believe you should have you should know the answer to the next question I'm about to ask by virtue of your experience and rank in the army before you were retired. Now, in the hierarchy of authority in the armed forces, with whom lies the ultimate authority of command?
The ultimate authority of command of the Nigerian Army rests with the President Commander-in-Chief of the Armed Forces, which he delegated to the Chief of Army Staff for day-to-day running of the Army.
The question is simple. These are appendage or addition you're adding. I didn't ask for.
I lost you for a moment, so you will have to go through that again, please.
Okay, sir. Yes, my lord. Witness, can you hear me, sir?
I can hear you loud and clear.
Now, I'm still going to repeat the question, but my lord lost us in the course of the proceedings. The question is, with whom lies the ultimate authority in the armed forces of Nigeria?
The President and Commander-in-Chief of the Armed Forces, and he delegates this power to the Chief of Army Staff for day-to-day run of the Army.
I'm so sorry. My volume is really poor. I don't know. I'm getting them to increase the volume.
Score, please.
Because I'm supposed to be hearing it loud and clear. Maybe you put on your own mic. Is your mic on? Are you the host? Tell Mohammed to come and put on his mic. Please take that again. Let me see if I'll hear you well now. Mr.
Very well, my lord.
Yes.
Very well, my lord. Witness, I repeat the question again, please. In the Nigerian Armed Forces, with whom lies the ultimate power and authority of command?
The ultimate power of command rests with the President and Commander-in-Chief of the Armed Forces, which he delegates to the Chief of Army Staff.
The chief of the Nigerian, the commander-in-chief.
The President and Commander-in-Chief of the Armed Forces.
And he delegates to the Chief of Army Staff.
Yeah, for day-to-day running of the Nigerian Army.
I'm okay. I wanted you to put on your mark. Okay, yes, please.
What you are saying in essence is that the Chief of Army Staff is a delegatee of the powers and authorities of the Commander-in-Chief of the Armed Forces. That is Mr. President. Is that what you are saying, sir?
Yes.
Yes.
Well, my lord. Witness.
Yes, please.
Please, I want to refer to your letter, your correspondence, dated 19th of June, 2016. Which you addressed to Mr. President and Commander-in-Chief of the Armed Forces.
Correspondence dated when?
19th of June, 2016, my lord. Can you remember that correspondence, sir?
Yes, I do.
Okay.
Addressed to the President and Commander-in-Chief.
Is that who you address your letter to? The President and Commander-in-Chief of the Armed Forces?
That is what the Armed Forces Act says we should address it to in such cases.
No, the question is simple. Are you, in this case, is it the Commander-in-Chief of the Armed Forces that you address that particular letter to?
Yes, to the Chief of Defense Staff.
Will that be Exhibit D? Mr. Omachi?
My lord, if we can be
Are you
guided by
referring to the letter marked as Exhibit D?
If you can be guided by the record of the court, my lord.
Appeal letter to the President, 19 June 2016.
Very well, my lord. That is the letter, my lord.
Okay. Yes.
Witness.
Yes, please.
With reference to the said letter just identified as Exhibit D, will I be correct to say that you addressed that letter to the Commander-in-Chief because in him lies the ultimate power and authority in the day-to-day running of the armed forces, particularly the Nigerian Army? Will I be correct to say so, sir?
Please, can you come again?
I said, with reference to Exhibit D, which is your letter dated 19th June 2016. Are you hearing me?
I can hear you. Yes, please.
With reference to the said letter, will I be correct to say that you addressed the letter to Mr. President and Commander-in-Chief of the Armed Forces? You can hear me just fast, sir?
I can hear you loud and clear.
Why is that?
Okay, good. That you addressed the said letter to the President and Commander-in-Chief of the Armed Forces because of the fact that in him lies the ultimate power and authority in the running of the affairs of the Nigerian Army and the entire armed forces. Will I be correct to say so, sir?
I addressed the letter to Mr. President because that is what the Armed Forces Act said we should do.
Okay.
Okay.
Witness.
Yes, please.
Let me just read back the last answer to my question. Your last answer, your answer to my last question, as a build up to the next question. You said I addressed the letter to Mr. President because that is what the Armed Forces Act says we should do. Is that your answer,
Yes.
sir?
Yes, please.
Please, will you be kind enough, sir, to refer us to the particular portion of the armed forces where this directive is contained?
Okay, if you give me a few minutes, let me go to the Armed Forces Act.
Well, even though this is a virtual court session, you are presently a witness, and I don't think you can just start going through any material. It's either you have the answer readily available.
He's not writing an examination now. Do you know the entire constitution of head, Mr. Omachi?
No, I don't.
You
It's just the
asked
way.
him a question. You need to give him the opportunity to get the answer.
Very well, my lord. We are guided by the wisdom of the court, my lord.
With due respect, my lord.
Where did you do?
What portion of the Armed Forces Act, Mr. Nwanko?
I'm going through the Armed Forces Act, my lord. I'm searching. I will be back in. I'll just get it now. But it's under the chapter 9, which deals with resignation, retirement, and resettlement.
Witness, let me help you. Are you referring to the terms and conditions of service?
Yes, terms and conditions of service. Okay, I'm coming, please. Okay, I found it, my lord.
Yes.
It's on page 35. That's chapter 9, 092E. And it says, an officer called up.
I think even on the face of Exhibit D, Mr. Omachi,
Yes,
if you look on the face of Exhibit D, the letter with which you, the letter on the basis of which this question was asked.
Yes, my lord.
It refers to paragraph 9.02C of the Harmonized Terms and Conditions of Service for Nigerian Armed Forces.
Yes, my lord. But the witness earlier on made reference to the Armed Forces Act, and it's not the same
Okay.
thing with the, yes. That's why I wanted to put into task to tell us the
Okay.
section of the Armed Forces
So,
Act.
Mr. Nwankwo, the question whether the particular portion of the Armed Forces Act,
My lord,
is it the Armed Forces Act you are looking at, Mr. Nwankwo?
sorry, please. It is the Harmonized Terms and Conditions of Service for Officers. Sorry, please, my lord.
Okay.
Yes, witness,
Yes, please.
would you be kind to read on page 35 of the Harmonized Terms and Conditions of Service,
Yes, please.
paragraph 0902E,
Yes, please.
to the hearing of the court.
An officer called upon to retire, resign, or to relinquish his commission shall, if he so desires, appeal to Mr. President, Commander-in-Chief, through the Chief of Defense Staff within 30 days to have his case reconsidered.
Okay, 0902D.
E, my lord.
C.
E.
E.
As in,
Okay.
E, as in echo.
Okay.
Yes, my lord.
Okay. And you say it is on page 35?
Yes, my lord.
My lord.
Yes, please, go ahead.
Witness.
Yes, please.
Now, looking at the sequence of the questions asked thus far and the answers you have given with regards to the power of the Commander-in-Chief of the Armed Forces of Nigeria, will I be correct to say that all the actions taken with reference to your retirement, compulsory retirement, was taken by the President and Commander-in-Chief of the Armed Forces of Nigeria? Will I be correct to say so?
You are incorrect, sir. You are incorrect, sir.
No, I've not finished. Taking into account the fact that these officers or whosoever has taken those actions took them on behalf of the President.
You are still incorrect, sir. It was not taken on behalf of the President.
Okay.
Okay.
Witness.
Yes, my lord. Yes, please.
Recall earlier that you had told this honorable court that the President and Commander-in-Chief of the Armed Forces of Nigeria carries out his function with regard to the armed forces through delegatees of his powers. That is the Chief of Army Staff. You specifically mentioned the Chief of Army Staff as a delegatee of the powers of the President. Your Adela said so. Am I correct?
I said so.
Good. Now, having said that, will it not amount to approbating and reprobating when you deny the fact that the actions taken by persons acting on the powers of the president, that they were not acting on behalf of the president? Will that not be approbating and reprobating at the same time, sir?
I don't know what you mean by appropriating and reprobating, but what I know is that you can delegate powers to someone and he will still go ahead and do what he likes. I'm not sure the president would ask somebody to do what is not constitutional.
So, now, okay,
Let's get that clear. The witness said earlier that the president delegates his powers to the chief of army staff as it relates to the day-to-day running of the Nigerian army.
Yes,
and the
my
witness
lord.
also says that the actions taken in respect of his compulsory retirement was not taken on behalf of Mr. President.
it's okay.
And the question is whether that does not amount to approbating and reprobating. That is the basis for this question, right?
Very well, my lord. That is it.
Okay. And the witness is saying that it is true that the president delegates his powers, but still it is not. He does not believe that he has asked the chief of army staff to do something unconstitutional. Or what is the answer to the question? Is that what he said?
That's what he said.
Okay.
That's what he said.
In other words, the chief of army staff acted on his own.
Absolutely, my lord.
Yes.
But we agree on one thing, which is on the record of the court, and that is that your letter of 19th of June 2016 in Exhibit D was addressed to Mr. President and Commander-in-Chief.
It was, my lord. Because if it was addressed to the chief of army staff, then probably he will be appropriating and reprobating like you have just mentioned. That's why I wrote to the chief, to the Mr. President.
I thought you said you don't know what I meant by appropriating and reprobating, sir.
Now I have learned from what you've just said, and I now know what you mean.
Well, very well.
So it is correct that Exhibit D was addressed to the president?
Yes, my lord.
Yes.
I would therefore be correct to say that Mr. President is a principal factor with regards to the issue of your retirement, taking into account paragraph 90902E of the Terms and Conditions of Service, which you just read out. Mr. President is a principal factor because that provision, imposes a duty on you to write a letter of complaint addressed to Mr. President.
First and foremost, that letter said he may, if he so desires. So it is not a burden. And secondly, he is not a factor in the retirement. It is just there to make sure that nobody is retired illegally, unconstitutionally. That is a remedy. Not that is a factor to the retirement itself.
So it is not in all cases that you need to write to the president.
Yes, my lord, absolutely.
Only when you feel aggrieved.
Yes, my lord.
But in this case,
And
you chose
you
to.
wrote Exhibit D because you felt aggrieved.
Yes, my lord.
Yes.
Witness.
Yes, yes, please.
You know, the name and person of or office of Mr. President has resonated so much in these proceedings as the authority or the final authority with regards to the affairs of the armed forces. Now, the question is, looking at the composition of the defendants in your action, is the president a party to this action?
Can you take that again, Mr. Machi? I think I need an earpiece.
Very well, my lord.
Yes.
Witness.
I can hear you, sir. I can hear you clearly.
Yes.
Okay, sir. The name and office of the president and commander-in-chief of the armed forces has resonated so much in these proceedings today.
Yes, my lord.
And you also said that in him lies the ultimate power and authority with regards to the running of the day-to-day affairs of the armed forces. Now, my question is this. I want you to take a look at all the defendants listed in your suit and tell this honorable court whether Mr. President is a party to this action.
Because the chief of army staff is delegated on his behalf, so he's a
the
party.
the question is asked in a manner asked deliberately to elicit a yes or no answer. Is the president a party to this action? Yes or no? Look, you just get the answer by looking at your statement of.
Yes, he's a party.
Mr. President is a party.
Yes, because chief of army staff is representing him.
Excuse me, calm down. You say it's a party.
I'm welcomed.
Okay, let me not use the popular parlance. Be calming down, sir.
I'm calmed. I'm welcomed. I'm welcomed.
It's okay. Okay. Please, sir, I want you to read out the names of all the parties, if you have them, or if you don't, I can read them.
I have them. If you want me to read them, I can read them. If you want to read them, you can read them.
Okay, you kindly read them, sir. I wouldn't mind.
Nigerian Army.
Yeah. As the first defendant, yes.
Chief of Army Staff.
Okay.
Who is delegated by the president.
No, it's not so stated. Don't read what is there, please. Don't add anything.
Nigerian Army Council.
Okay.
Armed Forces Council.
Okay.
Chief of Defense Staff.
Okay.
Federal Ministry of Defense.
Okay.
Permanent Secretary, Federal Ministry of Defense. Attorney General.
There's no party named President and Commander-in-Chief of the Armed Forces of Nigeria in this suit. Yes or no?
There is, because the person representing him is here.
Yes or no? I'm not talking of representation. I mean, actual naming of the president as a party. Is it there as party number 9, or anywhere in the among the defendants as composed on your process?
Directly, no.
Good.
But indirectly, he's represented by Chief of Army Staff.
No, please, you have answered the question, sir.
Just for emphasis, my lord.
The president is not directly sued.
Yes, my lord.
But indirectly.
Yes,
through
my
the
lord.
Chief of Army Staff.
Yes, my lord.
Okay, since you want us to go that way, let me ask you. Is there anything? Is there anything, because the Chief of Army Staff is listed as the second defendant? Am I correct, sir?
Yes, sir.
Is there anything like a kind of appendage to that name of Chief of Army Staff suggesting or stating that is acting or representing the Commander-in-Chief of the Armed Forces of the Bloc of Nigeria?
It's implied,
so stated
sir.
on your, okay.
It's implied.
Thank you. No, is this so stated? I'm not asking whether it's implied. I'm asking whether it's actually stated on your process. Yes or no? Even the blind can see, sir. I'm just asking the question deliberately, just to drive home a point.
He's not stated directly.
It's not. Is it stated there? Yes or no?
Directly, no.
On the face of the process, it is not so stated.
Very well. Thank you, my lord.
Yes, my lord.
Yes.
Okay. Thank you, my lord.
Yes.
Witness, sir.
Yes, sir. Yes, sir.
I want to refer to your claims.
Yes, sir.
Paragraph 5A.
5 what?
5A of your claim, sir.
1 minute, sir.
Of what?
5A on the statement of facts. The paragraph relating to
the amended statement of facts.
Thank you, my lord, for the correction. The amended statement of facts. Paragraph 5A.
1 minute, sir.
That is under the reliefs being claimed by your humble self, sir.
1 minute, sir.
Very well.
Oh. Five A.
Yes, sir.
That's the last page.
Let me see. Claims now. Minutes.
Before the date, dated the 14th day of July, 2022.
Okay, I have seen it.
Okay. 5A.
5A. I'm sorry, I'm coming. The 5 I have here does not have A.
Sir, we are talking of under the paragraph, by reason of the foregoing, the claimant claims.
I think those that's amended further. I mean that amended statement of facts. There has been some misnumbering. There is a certain paragraph 5 on which is on page 3 of the document, and then there is yet another. I think that would be the claims. I mean the claims of the claimant.
Yes,
where
sir.
it is listed.
It's the claims of the claimant, yes, sir. Under
so
the
paragraph
claims.
5A is on the last page of your process. Maybe let me read the court's copy. Which were bound by the records of the court. It says an order that the defendants, particularly the 1st, 2nd, 3rd, 4th, 5th, and 6 defendants shall pay to the claimant all are, I think, arrears. I think they want to write arrears there of salary. Hello.
Yes, my
Hello,
lord.
sir. Yes, my lord.
Yes.
Okay.
We're with you, man.
Yes, all arrears of salaries, perquisites, emoluments arising during the period of the purported compulsory retirement measured by the payments made to the claimant's contemporaries in the Nigerian Army of the 40th regular course and in accordance with the higher ranks to which the claimant would have been entitled but for the compulsory retirement. So that's the content of the paragraph 5 which Mr. Omachi is referring to.
Yes, my lord.
Thank you, my lord. Now,
You're welcome.
Clement,
Yes, my lord.
I would like to ask 1 or 2 questions from the paragraph 5A.
Yes, please.
What you're asking for is payment of arrears of salaries,
Yes.
perquisites, emoluments arising during the period of the purported compulsory retirement. Now, the emphasis here is measured by the payment made to the claimant's contemporaries in the Nigerian Army of the 40th regular course.
Yes, my lord. Yes, sir.
Yes, and in accordance with the higher ranks to which the claimant would have been entitled, but for the compulsory retirement.
Yes, sir.
Now, you were compulsory retired at the rank of colonel.
Yes, sir.
Yes.
Witness,
Yes, sir.
you have just told the court that you were compulsory retired at the rank of colonel.
Yes,
Now,
sir.
If you are remaining in the army,
Yes, sir.
your climbing to the next rank would have been through a process of promotion. Am I correct?
Yes, sir.
Yes.
That next rank would have been Brigadier General. Am I correct?
Yes, sir.
Yes.
Will I be correct to say that promotion to the next rank, particularly from the rank of colonel to Brigadier General, has laid down procedures that must be followed? Is that
You are
correct, sir?
correct. You are correct.
Okay.
Yes.
Now, would you be kind enough to to tell us what these procedures are to get promoted from colonel to brigadier general in the Nigerian Army.
You must have served for 4 years on the rank of major of brigadier colonel. No, 5 years actually. 5 years. Secondly, you must have attended the National Defense College for regular commissioned officers. And
You must have
thirdly,
served on that rank for 5 years.
5 years, my lord.
Yes.
You must have attended the National Defense College or its equivalent, which is the NIPS.
National
Defense
Defense.
College. And then you must have...
Or its equivalent.
Yes, my lord. And you must have...
NIPS.
Which is NIPS, yes, my lord.
Yes.
And you must have 3 years personal evaluation reports.
Yes.
3 years evaluation report, which
Yes,
must
my
be
lord.
favorable. Which must be positive
favorable.
or favorable.
Yes, which must be favorable, yes.
Is that all, sir?
That is all.
Yes.
Yes, you have just listed the condition precedent to be complied or to be met before promotion is attained from colonel to brigadier general.
Yes, sir.
So will I be correct to say that promotion from colonel to brigadier general is not an entitlement per se?
It is an entitlement. If not, it will not be put, the conditions will not be put in the terms and conditions of service.
What do you understand by entitlement, sir? When you say you are entitled to something.
Whether you are deserving or not, you get it. That's an entitlement. But if there are laid down procedures and you meet all the laid down procedures, then it is not at the whims of anybody to deny you of promotion.
So it is not an entitlement.
It is not once you meet the conditions.
Okay, it is an entitlement.
Yeah, it is an entitlement once you meet the conditions.
Yes.
Okay. And conversely, if you don't meet the condition, you don't get.
I have lost you, sir. I have lost you, sir.
Okay. Can you hear me now, sir?
If you do not meet the entitlements, I mean the conditions,
you will not be promoted. Yes, sir. Yes, my lord.
Okay, if you don't meet the conditions or requirements, you will not be promoted.
Yes, sir.
Will I therefore not be correct to say that it is not actually an entitlement? But a position that can only be attained subject to fulfilling certain conditions?
If you meet the conditions, it is an entitlement.
Okay, fine. I don't want us to go back and forth on this.
Thank you, sir.
Yes.
Yes.
If you still have your claims, my Lord has assisted immensely by reading out the claims in paragraph 5A. Are you with your claim, sir? Are you with your claim, sir?
Yes, sir.
Okay. Your claims are numbered paragraph 1 to 6.
That's the amended claim, sir.
Yes, sir.
Yes.
1 to 6.
Yes.
One to 6. No. I have more than 6 here.
There's 4 has 2 arms, 4 and 4A, and then there's 5 and 5A. But the numbering is 1 to 6. Perhaps you are not looking at the amended claim.
That's precisely what I'm looking at, my Lord.
There is 1, 2, 3, 4, 4A, 5, 5A, and 6.
Are you there, sir? Witness.
I am not there yet. 1 minute, sir.
Mr. Omachi, maybe you could just proceed to ask your question.
Okay, let me just ask my question.
Yes, sir.
Please, is there anywhere, any portion of your claims where you stated that you met the requirements that you just listed for you to be entitled to be promoted to the next rank with your
Yes,
peers?
sir. Yes, sir.
Is there anywhere you so stated?
Yes, sir.
Categorically,
Yes,
that you
sir.
met, that you have served 5 years on the rank, that you have attended the NDC or its equivalent, which is NIPS, or that you have 3 years performance evaluation report written in your favor, and which you are next to your process as evidence? Is there anything of that nature, sir?
I stated that, but I did not annex my favorable personal evaluation reports, because when they were rendered, I was given, and they now became public documents. I mean, they now became, the Army kept them, confidential documents.
But
Mr. Omachi, let me call your attention to something.
Yes, sir.
What you are asking the witness, if he has stated, if he has, it wouldn't be in the claims, it would be in his deposition.
Yes, sir.
So perhaps if you take a look at his deposition, we'll know if he has, and if he has not, then I think this is something you make a matter for address, because
Even
he
in his
has himself told us the conditions.
Yes. Witness.
Yes, my Lord. Yes, sir.
My Lord, thank you we are most guided, my Lord.
Thank you.
Now, witness, His Lordship has graciously, drawn our attention to your claim.
The witness deposition.
Okay, let's go to your witness deposition. Caption: further sworn statement of witness. Annexed to the amended statement of claim or amended statement of facts.
I don't have that particular one here.
Okay. Which one do you have? You don't have the amended statement of facts?
The first one I have, before the amendment, I don't have the amendment, but the first one was, this was brought out succinctly in paragraph 12. In paragraph 12 of, not the amended one, the first one. It was brought out succinctly there.
Can you read it?
Can you read it? Okay,
Paragraph 12. I was a participant in and successfully completed a course of studies at the National Defense College, Abuja, designed for officers of the rank of colonel or the equivalent in the armed forces, which is in the nature of an eligibility course for promotion to the rank of brigadier general after 5 years of service as a colonel. And I have completed 5 years of service as a colonel and be eligible for promotion as a brigadier general in 2016.
Amended statement of facts, paragraph 12. Let me see.
No, this is not, my lord, it's not the amended one. It's the first one I made before I amended.
Okay, it will be in paragraph 13 of the further amended, Mr. Omachi.
It's not there, my lord.
Paragraph 13
It's not there, my
of
lord.
the further amended statement of facts.
Further
That
amended
is,
statement.
yes, because you were looking at his
I'm looking.
claim.
No, further statement of witness, my lord. Further statement of witness. Whether it is there. Further statement of witness annexed to the amended statement of facts.
That's the process filed on the 14th of July.
Yes, my lord. Already, my lord.
Yes.
There is an amended statement of facts.
Yes, there was an amended statement of facts,
which completely obliterates the original or initial statement of facts.
Yes.
Which replaces the original statement of facts. And
then
then
there
if
is
we're
a
having,
further amended statement of facts.
Yes, my lord, what I'm saying is that whatever documents, whatever witness deposition that was annexed to the original statement of facts, which has been amended, is no longer in existence. It's only the amended version now that, and the statement annexed here too, that will form part of the record of the court, that the court can take cognizance of.
Yes,
I think that is the position of the law.
I agree with you.
The document he just read out.
Yes,
sorry, my
it's
lord.
the original one.
Is the original one, and what he has just read out is not contained in this further, or what he captioned as further sworn statement of witness. It is not there, my lord. It's not there.
And Mr. Dr. What's that your name again?
Yes, Omugele.
Oh, Mugele.
Omugele.
You filed a further amended statement of facts on the 15th day of December. Was it 13th or 15th of December? 15th day of December 2022.
Yes.
It didn't come accompanied by a statement on oath.
My lord, this is the matter for address because that amendment relates back. It's a matter, it relates back to the beginning. So my lord will address that with respect.
Further amended statement of facts.
Yes.
The point is that if we have a statement of fact and then we have an amended statement of fact, the question will now be which one will the court have recourse to in the proceedings? Which one will the court take cognizance of? Is it the original statement of fact or the amended statement of facts? If my learned senior wants to leave that very crucial point for address, we will we'll respond or make our submissions in the course of our address as well.
My lord, we're in the court now.
If we can make progress with the kind permission of my lord.
Yes, you can make progress because it looks like we are going to keep going round and round at this rate.
Yes. What's my name?
Yes.
My lord, we'll rest at this point. That will be all for this witness.
So let me be sure what was your last question.
Yes, my lord.
You asked the witness whether he can show you in his deposition on oath
Yes, my lord.
whether or not he is qualified for
Yes, my lord.
promotion.
Yes, my lord.
That was the question.
Yes, my lord. And that
It
question is
appears we do
relevant.
not have an answer.
Well, my lord, that question is relevant to or strictly related to his statement on oath annexed to the amended statement of facts. And in his said witness statement on oath annexed to the amended statement of facts, there's no deposition related to the question and asked, which is whether he had attained the requisite for promotion to the next rank. Those facts are not contained there. They are not contained. He only made reference to his earlier statement contained in the original statement of facts, which has been amended and is now superseded by the amended statement of facts.
So what you are pointing out basically is that the last amended statement of facts did not come with a deposition, with a corresponding deposition.
Yes, sir. Containing the facts relating to whether it's qualified to the promotion to the next rank.
The witness
Because that question
took us back to his first deposition.
was not superseded by the amended statement.
That's the one that was filed along with the originating process.
Yes, my lord. So the question will now be between the two statements of facts, which one is live before the honorable court? The one that's been amended, or is it the amended version or the original version? I'm a learned senior.
Sister, you said in that your deposition that you had attended the defense college.
I did, my lord. And I had served for 5 years. And I had 3 favorable, personal evaluation reports.
And Omachi,
Just okay.
You are saying that the further amended statement of facts does not have a corresponding statement with witness statement on oath.
Relating to the assertion being made by the witness, my lord. My lord, just one last follow-up question before I rest, my lord. If my lord can indulge me, just one more last question. Then we'll rest our examination.
So what you are looking at, Mr. Machi, effectively is the witness deposition dated 14th July 2022.
Yes, my lord, which is annexed to the amended facts, my lord.
And it does not have that assertion.
It does not have that assertion, my lord.
Thank you.
Most obliged, my lord. Just one more last question, my lord.
Yes.
Witness, in the
Yes,
course of
sir.
your evidence in chief, the last time you testified in court that your lawyer led you in evidence,
Yes, sir.
you were led to tender 4 exhibits, marked as exhibit A to D. Am I correct?
Yes, sir.
There are 5, Mr.
Oh,
Machi. I have exhibits A, B,
okay.
C, D, E.
E, okay.
Yes.
Thank you for the correction, my lord. Most
Yes.
obliged, sir. Now, among these exhibits A to E,
Yes, sir.
is there anyone among them that is a certificate of qualification from the National Defense College or its equivalent?
None.
Is there anyone constituting 3 years favorable performance evaluation reports among the said exhibits?
1 minute, please.
Mr. Machi, do you really need to do this? We know what the exhibits are.
As the court pleases. As God pleases.
As formed part of the records
They are,
of the court. The only thing I
as
have
God
here,
pleases.
notification of commission and posting, Exhibit A, Armed Forces Harmonized Terms and Conditions of Service, Exhibit B, compulsory retirement, Exhibit C, appeal letter to the President, Exhibit D, and reply to appeal, Exhibit E. We know what the documents are. I
As the
think
court
you have made
pleases.
your point.
We are guided by the wisdom of the court, and we are most
Yes.
obliged for the patience and indulgence of the court. With that, my Lord, we rest our cross-examination of the witness, my Lord.
Thank you. Re-examination. Dr. Umugele.
Yes, my lord. No re-examination.
No re-examination. So the witness is discharged.
As the court places.
As court pleases.
Mr. Umugele, is that your case? Doctor.
Yes, please. That's our case. Yes, my lord, that's
Okay.
our case.
My Lord, if
Mr. Omachi.
my Lord,
Yes.
if we may get the kind indulgence of my Lord to say some
Yes.
facts off record, my Lord.
Yes.
I know that there are efforts being made
Okay.
for this matter and sister matters, that falls in the category of the kind of case that the witness the claimant has brought to this noble court.
Okay.
I know that there are efforts being made, to my knowledge, to find a way of resolving the matter amicably.
Yes.
That is why we have not even filed our statement of defense. But we're quite optimistic that by now the matter would have gotten some positive feedback with regards to the efforts being made to have the matter resolved administratively, as it were.
Okay.
I know that effort is still being made. So I will crave the indulgence of the Lord.
Yes.
Before we open our defense, to grant us the indulgence of confirming from the defendants, particularly the Chief of Army Staff and the Directorate of Legal Service, the state of affairs, how far they are gone with regards to having the matter resolved.
Okay. So this kind of facts should actually be on record, Mr. Omachi. You said you wanted to say the facts off record. Don't you think it should be on record that there are moves to settle?
Except if my learned senior is, because these are efforts that I know are going on or being made, but have not been communicated in writing
Because
officially.
as a matter of fact, even way back in 2022 December, Dr. Omugele, no, somebody called Enegbani, who at the time appeared for the defendants, even told the courts that the principal counsel had intimated him of some initiative to settle out of court. Do you know Mr. Enegbani?
Very well, my lord. Yes. In fact, I gave him that information. He supplied to the court.
Okay, so all the way back 2022, he announced that he was here to file his defense. However, there were moves to settle out of court, and that was very gratifying to me, if you ask. I thought it was a good development. And we adjourned for report of settlement.
Okay.
Unfortunately, you couldn't settle, and here we are. So,
not that we couldn't settle, it's just that feedback on the settlement was not.
I can imagine the bottlenecks and bureaucracy in the
my lord.
The service nowadays.
Yes, my lord.
Well, has always been.
Lord. If I can be granted some kind of indulgence by the court, I will confirm with the Director of Legal Service on this position to confirm from him officially whether the matter is still being settled or not, because that is what I was told. But I needed to get an official response from them so that they can report to the court.
That's okay. If you want, I will just note it, and then whichever way you look at it, we'll adjourn for. What do you want us to adjourn for? For defense or for report of settlement? In the event that settlement fails, then you proceed to defense.
Yes, sir. We'll be more settled. More comfortable with a report of settlement.
Dr. Omugele, are you averse to settlement even at this point?
My lord, what we would just like to say is that the question of settlement has been an ongoing thing, and we're in the second year now. There's been no suggestion. Last time there was any appearance for the defendants was the very day your lordship read out. That is in December 2022. There has been no appearance to indicate what moves were being made, the progress made, and that's what brought us to the present position today. And that was why we considered the adjournment at that time, because the witness was physically present for cross-examination.
Yeah, that's true.
Yes,
well, thankfully, we are done with that now. We have crossed that hurdle. The witness has been cross-examined, and the claimant has closed this case. So now we are looking at settlement or defense.
Yes, my lord. In terms of defense, I would like to quickly say that the defendants did not do any payments. The defendants did not deliver any pleadings.
So, can
Either
you
at the
go over
time
that
of,
again?
yes, my lord. With regards to the question of defense,
Yes.
the defendants did not deliver any pleadings in this matter.
Yes,
Even after, yes,
Mr.
even after
Omachi
we came back from
has said
court of
so,
appeal.
that is
Yeah.
even the reason why they are yet to file their defense.
Yes, my lord, but I respectfully believe that that is not a reason for not filing a defense, because it's a 2016 case, and we came back from the court of appeal. The fact that there is a defense does not mean that settlement cannot be attempted. Settlement can be attempted even if there is a
Okay,
defense.
that is true.
They don't have a pleading. And the fact, my lord, with respect, my lord,
Yes.
the fact that they do not have a pleading affected our presentation of the case. We have to present it on the basis that the only pleading is ours.
Don't know why Dr. Mugele's
My lord, and with your lordship. My lord,
so far away. Yes.
can your lordship hear me now?
Yes, I can hear you.
Yes. What I'm saying is that the fact of defense not having been filed my lord, that is 8 years into the case, and 3 years after we came back from the court of appeal.
So, Mr. Omachi, can you hear me?
Yes, yes, I can hear you, my lord. Sorry about that, my lord.
Okay, did you hear what Mr. Dr. Mugele said? The settlement moves do not remove the necessity to file a defense. Is that what you say, Mr. Omugele?
No, that's our position. Because after the preliminary objection was decided in their favor, I can understand that. But we came back from the court of appeal. We should have delivered the defense. If we are
So before
settling, we
this
can go
matter
ahead.
even went on appeal, they hadn't yet filed a defense?
They didn't because of the nature of their objection.
Okay, that's okay.
Yes.
So, Mr. Omachi, you have heard. I'm going to adjourn for defense. And if before then you are able to obtain the necessary feedback, then you will inform the court on the next adjourn date. Is Mr. Omachi still with us?
No, I will not announce. I want to take you.
The last matter I adjourned, what day did I adjourn it to? In the court. 25th June. Okay. 25th of June.
My lord, the date is convenient for me.
Okay, I will adjourn the case for defense. If before the next adjourn date, learned counsel for the defendant is able to obtain a feedback, then the court will be duly informed. Settlement is highly welcome. The case is adjourned to 25th June 2024 for defense.
The court pleases.
Thank you very much, counsel.
Okay, my lord.
So I'm going to proceed to deliver a judgment now. And I'll be reading directly from this computer. So Mohammed, you can call the next case. Call the case.
Case number NSN/ABJ/325/2020 between Samuel Shikashe and First City Monument Bank. Lord, parties absent.
Appearances. Appearances. Any representation in this matter?
My lord,
My lord, I'm very sorry.
I can see the plaintiff's counsel. I'm wondering whether he's aware that the matter has been called. I can see him.
Yes, I
but
can see him
obviously it's
too.
not.
Mr. Opin.
Yes, sir.
My lord,
Yes.
my lord, I'm appearing for the claimant.
Yes.
CSOP. Claimant is in court.
Claimant present.
Claimant present in court. CSOP for the claimant.
Yes.
My lord, I am AUS Ogwajama. AUS initials. Ogwajama spelled as OGU.
Yes.
AJA.
Yes.
Double MA. My noble lord, I appear for the first defendant, FCMB.
Yes.
Yes, my lord, I'm very sorry. I got the information about this judgment very, very late when I was in chambers. So I just have to come the way I am on rope. I don't know. I know the court will not accept a representation without being roped. So I just have to come to follow the judgment, my lord. I actually represent the second defendant.
What's your name?
I am PM Onoja for the second defendant, my lord.
But
I'm
I
so
saw
sorry.
Mr. Barminas. Is it Barminas? Is it Barminas? I saw him online earlier.
You know, he has been sick. Although he's aware he has been sick, he underwent
PM
surgery.
Onoja.
Yes, my lord. He underwent surgery, so I have to be on the standby.
So I'll proceed to deliver the judgment.
As a
As
court
the
As a cop.
please.
Like I said, I'm going to be reading directly from this computer. And I'm going to go straight to the decision part of this judgment so as to save time.
Court please.
The
That's my law
claimant has
please.
brought two defendants to court in respect of his claims. In paragraph 2 of his amended statement of facts, the claimant said the first defendant was his employer for the purpose of this suit, while in paragraph 3, he said the second defendant is his pension fund administrator. The claimant pleaded that he was employed on 8/1/2004 and he voluntarily resigned his appointment with his employer in June 2012. In his evidence, the claimant said upon his resignation, he collected the statement of account of his retirement savings account, RSA, from the second defendant, wherein he discovered non-remittance of his pension deductions for several months, insufficient remittances which left shortfalls, and late remittance of deducted pension funds. From the averments and claims of the claimant in the amended complaint and statement of facts, his case is basically a claim for unremitted pension during the period he was in employment. His complaints in the case on the basis of which he sought the reliefs in the amended complaint are adequately captured in paragraph 7 of the amended statement of facts, where he pleaded that his former employer was guilty of non-remittance of pension deductions for several months, insufficient remittances, leaving shortfalls, and late remittance of deducted pension funds. He also alleged that every month, his former employer fails to remit the correct amount of pension into his RSA, such that every remittance was far below the statutory minimum. The first and second defendants denied the claims of the claimant. The first defendant averred that the claimant was in the service of NUB International Bank Limited and later First Inland Bank PLC, where he retired, and said NUB International Bank Limited and First Inland Bank duly remitted all funds due to be paid into the claimant's retirement savings account. The first defendant further averred that it is not liable for the non-remittance of pension deductions, if any, accruable to the claimant, or for any insufficient remittances, if any, or for late remittance, if any, of deducted pension funds to the claimant. The claimant is not entitled to either 142,572,232 naira 94 kobo or 162,144,572 naira claimed in this suit, or any other amount whatsoever from the first defendant. On its part, the second defendant denied liability for the claims of the claimant and averred that all the remittances made into the claimant's retirement savings account are reflected in the claimant's retirement savings account statement. Accordingly, the burden of proof of the claims in the amended complaint rests on the claimant. This burden of proof is placed on the claimant in sections 131 and 132 of the Evidence Act 2011. See also Umeojako against Ezenamo, 1990. Phillips versus Odan Commercial and Industrial Company Limited, 2012. Thus, since the claim of the claimant is for recovery of sums of money, the burden of proof of the sum claimed rests squarely money. The burden of proof of the sum claimed rests upon squarely upon the claimant, and he has the onus to prove how the defendants came to owe such amounts of money. See NBN Limited versus SCDC Company Limited, 1998. In, in cross-examination by counsel for the first defendant, the claimant told the court that he was first employed by NUB International Bank and then First Inland Bank PLC, where he retired in 2012. He also said he was not at any time employed by the first defendant. The claimant further said his complaint in this case is about non-remittance of his pension and under remittance of pension into his RSA. These acts were done by NUB and First Inland Bank and not by the first defendant. From the evidence of the claimant, both in chief and in cross-examination, it needs to be stated here that the claimant has not shown that the first defendant is liable for his claims for under remittance or non-remittance of his pension during the period of his employment, that is from 2004 to 2012. The first defendant was not his employer in these periods, and the claimant has not pleaded any fact or given any evidence to link the first defendant to his former employers or his claim for payment of pension under his former employers. His mere averment in paragraph 2 of his amended statement of facts that the first defendant be considered his employer for the purpose of this suit is not sufficient to link the first defendant with his former employers. I agree with the arguments of the learned counsel for the first defendant that the claimant has not shown how the first defendant is connected to his claims in this suit. I've heard the arguments of the learned counsel for the claimant in the final written address, where he wants this court to consider extraneous facts not placed before the court to hold that the first defendant acquired the claimant's former employer. Those facts the claimants counsel want me to look into are not matters which this court can take judicial notice of. Again, it will amount to speculations for this court to toe the line of the arguments of learned counsel for the claimant. Without any doubt, the claimant has not shown the link between his complaints in this case, which is the non-remittance of his pension or under-remittance of pension into his RSA, to the first defendant. These acts were done by NUB and First Inland Bank by his evidence. The first defendant was at no time his employer. It is clear to me that the claimant has not disclosed any cause of action against the first defendant with respect to his claim for his unremitted pension. For the second defendant, it is only a PFA. The claimant did not disclose any wrongdoing against the second defendant with respect to his complaint of non-remittance of his pension or under remittance of pension to his RSA. In relief one sought by the claimant in the amended complaint filed on 21st February 2022, the claimant claims the sum of 162,144,572 naira from the defendants. The content of the relief reveals that the sum includes shortfalls of pension remittances from February 2004 to June 2012, and accrued interest at monthly rate of 5% for the months of February, March, and April 2004 under NSITF Act, and 2% from June 2004 to October 2020 under the Pension Reform Act. In paragraph 58 of the amended statement of facts, the claimant pleaded thus, quote, the claimant calculated the principal sum held back by the defendants. He has calculated interest accrued on the shortfalls and late remittances. The total figure as at October 2020 is 162,144,572 naira, unquote. From the claim in relief 1 and the averment in paragraph 58, it is clear that the sum claimed by the claimant in relief 1 is the total sum of his unremitted pension and interest accruing on the unremitted pension up to October 2020. The case of the claimant with respect to shortfalls or unremitted part of his monthly pension is basically that his former employer was not remitting what ought to be remitted as his monthly pension into his RSA. In his amended statement of facts, the claimant pleaded the sums which ought to be remitted monthly as his pension into his RSA from June 2004 to June 2012 in paragraphs 26, 27, 28, 29, 30, 31, 35, 37, 42, 45, 47, 48, and 49 of the amended statement of facts. The pleadings in these paragraphs of the amended statement of facts are the averments of the claimant with respect to his claim for shortfalls in pension remittances. The evidence adduced by the claimant to establish the facts in the above paragraphs of the amended statement of facts is the evidence he adduced on 6 December 2021 and on 19 October 2022. On 6 December 2021, the claimant adopted the written statement on oath which he made on 14 September 2021 as his evidence. And on 19 October 2022, he adopted another witness statement on oath, which he made on 21st February 2022, and told the court to adopt it as his further evidence in addition to the earlier evidence that he gave on 6th December 2021. I have examined the evidence adduced by the claimant on 6 December 2021 and on 19 October 2022 as contained in the witness statements on oath made on 14 September 2021 and 21st February 2022, and I find them to be contradictory in material respects, particularly with regard to the amounts of the claimant's salaries and amounts of monthly pension which the claimant claims ought to be remitted into his RSA but were not remitted or incomplete remittances. The observed contradictions in the evidence of the claimant are as follows. Now, counsel, this is a quite lengthy analysis, but it's already I'm going to skip reading it out because the number from 1 to 10 of those contradictions, they are listed, so you get it. Yes, so I'll just proceed without reading through them. The above presents the two versions of oral evidence placed before the court by the claimant to prove his claim for payment of his outstanding or unremitted monthly pension. Since both versions of the evidence are what the claimant has placed before the court to establish his claims, this court does not have any discretion to choose one and discard the other. Inasmuch as the claimant decided to rely on both evidences, the court is bound to consider both evidences. Now, in considering the evidence of the claimant, I find the evidence inconsistent, conflicting, and contradictory. Contradiction or inconsistency in evidence connotes the act of reversing oneself or stating the opposite of what one had said in his evidence. It is a deviation or retraction of what one had earlier said. Two pieces of evidence contradict one another when they are by themselves inconsistent. See Dawaki General Enterprises Limited versus Amafco Enterprises Limited, 1999. Matthew versus Atabo, 2015. It is the law that where the evidence of one witness is contradictory, such contradiction weakens or discredits the evidence of the witness, and the court can disregard the evidence, especially where there is no other witness who testified in support of either of the two versions. CACB Limited versus Nwadiogbu, 1994. Where the evidence of a witness is contradictory, the effect is that the court cannot pick and choose which of the two versions of the evidence to believe. The court is bound to reject both versions. See Sylvia versus INEC, 2018. Edosa versus Ogenware, 2019. Kayili versus Yilbok, 2015. However, for a contradiction or conflict or inconsistency in the evidence of a witness to be fatal to the extent of being rejected, such conflict or contradiction or inconsistency must be material, substantial, and fundamental to the main issue in controversy before the court, as would create some doubts in the mind of the court. See MTN Communication versus Hansen 2017, Lawson versus Afani Construction Company Limited 2002. In other words, before a piece of evidence is discountenanced for contradiction, the contradiction must be material to the determination of the issue in dispute. Although the claimant claims the sum of 162,144,572 naira as the shortfalls in his pension remittances from February 2004 to June 2012 and accrued interest on the shortfalls, he gave two different versions of evidence on how the sum he claims accrued. In view of the two versions of the evidence of the claimant, I find the contradictions in his evidence to be material and fundamental, and accordingly thrown serious doubt on relief one sought by the claimant. In the circumstance, I am constrained to reject the contradictory versions of the evidence adduced by the claimant. I have also seen Exhibit C10, 30 to 34, tendered in evidence by the claimant, where he made a computation of the sums making up his claim. The claimant arrived at a total of 142,572,232 naira 94 kobo as at 31st October 2020 in computations in this exhibit C10 30 to 34. Then he also tendered exhibit C16 in evidence. This exhibit is titled Revised Calculation of Claims. In this exhibit, the claimant made a computation of the sums making up his claim, but using different figures and amounts in most of the calculations, different from those in Exhibit C10. And at the end of the computation, the claimant arrived at a total of 162,144,572 naira as his claims as at 31st October 2020. These documents are meant as the computation of the sum the claimant claims in Relief 1. But besides the manifest contradictions and inconsistencies in Exhibit C10 and C16, the documents were not dated and signed. The documents are therefore unreliable and are discountenanced. The result is that there is no credible evidence, either oral or documentary, left to prove the claim in Relief 1. Let me add that the sum sought by the claimant in Relief 1 include accrued interest at the rate of 5% for the months of February, March, and April 2004 under the NSITF Act, and 2% under the Pension Reform Act from June 2004 to October 2020. In his evidence, the claimant said the NSITF Act, Mohammed, you want to go and pray? Okay. In his evidence, the claimant said the NSITF Act prescribes monthly penalty of 5% for all shortfalls in pension remittance from the due date till the breach is remedied. And in his case, the penalty payable is for the months of February, March, and April 2004, and calculated up to 24th June 2004. Although the claimant mentioned the Pension Reform Act, he never said, either in his pleading or evidence, that he was entitled to 2% interest under the Pension Reform Act from June 2004 to October 2020. From the claim in Relief 1, the interest claimed by the claimant covers the period June 2004 to October 2020. However, the claimant failed to mention the exact amount of accrued interest for the period he claims interest. He also failed to compute the amount of interest or to show to the court what the amount of interest component in the sum claimed in Relief 1 is. Although he stated that by the NSITF Act, he was entitled to interest on late remittances, that alone would not entitle him to the sum he claims to include as interest. The claimant must clearly plead and prove the computed interest for the period in issue separately from the amount he claims as unremitted or shortfall of pension, and show to the court how the amount of interest he claims accrued. The claimant failed to do this. There is nowhere in his pleadings or evidence where he computed accrued interest from 2004 to 2020. He simply claimed a lump sum and said it includes accrued interest from 2004 to 2020. In the sum claimed by the claimant in Relief 1, he failed to prove both the pension part of it and the interest component of it. In view of the foregoing, I find that the claimant failed to prove the claim in Relief 1. Relief 1 is the main claim of the claimant. Reliefs 2, 3, 4, 5, and 6 sought by the claimant are dependent on the success of Relief 1. Since the claimant's relief 1 has not been proved, it implies that reliefs 2, 3, 4, 5, and 6 are bound to fail. In any event, I still examined the other claims and I find that they have not been proved. As for relief 3, where the claimant claimed for special damages accruing from wrongful tax, he did not plead special damages or wrongful tax and did not adduce any evidence to prove the claim. As for reliefs 2, 4, and 5, the evidence for their determination is the same contradictory evidence adduced by the claimant. The claimant is also not entitled to relief 6, having failed to prove his case. In the result, I find that the claimant has failed to prove his case, prove the claims he sought in this suit. This is in addition to my finding that the claimant did not disclose a reasonable cause of action against the defendants. The suit is accordingly dismissed. Parties shall bear their cost. Judgment is entered accordingly.
Court pleases.
As the court pleases.
As court
Thank
pleases.
you. So
My
we'll
lord,
get you.
I thank your
Thank
lordship for the industry that is manifest on the face of the judgment that was just delivered. I thank your lordship.
Thank you.
My lord, we are very grateful.
Thank you very much. I will make the judgment available right away. I read directly from the system and I made corrections while I was reading. So I'm going to have it printed and signed now before I go home. So if you can liaise with Mohammed, you can pick up your copies either today, later today, or Monday.
My lord,
let me. I thank you, lordship.
Thank you.
Yes, my lord. I just want to appreciate the industry my lord has employed during the judgment. You know, the exhibits are many, and it has not been easy reading through all the documents. So notwithstanding the fact that the judgment is against us, we appreciate the industry.
Thank you very much.
My lord.
We'll make it available immediately.
Very well, my lord. Very well,
all right.
My lord.
Enjoy the weekend and have a very good day.
Same to my lord.
All right.
Thank you, Lord.
Thank you.
Sorry, my lord. If my lord can hear me. Sorry, my lord.
Mr. Seth, can you confirm that my lord has that the court has risen? Mohammed.
Yes.
All right. Thank you.
Hello, Mohammed. Has the court risen?
Right, so much.
Yes, I had network issues here.
Okay.
And
the matter has been adjourned earlier.
No, it was on the verge of being adjourned. Then I had network issues.
Okay, it's 25th of June.
Okay, it's for defense or for the court of settlement?
Or possibly the settlement.
Okay, 25th June.
Yes, 25th June.
Though I wanted to apologize, can you apologize to my lord on my behalf that
yes,
I had network issues?
Okay.
It is not deliberate at all.
I will tell
Let me look as if I just went off like that.
Yes.
Please,
yes,
I had network issues. And by the time I reconnected, the court was already adjourned. Please, kindly explain to my lord, please.
Okay.
I'll call you back to confirm that you did that, I beg, please.
Okay, I will do that.
Please.
Thank you.
Please.